Good morning, members. We've got a quorum already, so we now call the meeting to order. We'd like to welcome Mr. David Wong and his colleagues. Item 1 on the agenda, confirmation of the minutes of the meeting held on the 7th of May. As we haven't received any proposals for amendments, can we confirm the minutes, please? Thank you. Last time, Mr. Dennis KWOK raised the issue of restricting or the restriction of contract override. Mr. Dennis KWOK raised some questions and replies were given to Mr. KWOK. Any further questions, Mr. Wong Yok Man? I'll see whether other members have got questions to ask. I'll ask later. Mr. Dennis KWOK, concerning the spirit of contract, is it sacred and inviolable? I think the answer is no. I have cited examples like the Employment Ordinance, the DDO, and in all these ordinances, there are provisions that override contract terms. So I think my main concern is where the line should be drawn in this piece of legislation. According to the administration, we should err on the side of protecting the copyright owners. But then Hong Kong is a relatively small market. And for major copyright owners like Facebook, if they can draw up private contracts which can override exceptions for parody, for example, then that really is a matter of concern. And the Bureau has not told us how these copyright owners will be making use of contract terms to override exceptions. Now, we are not saying that all exemptions or exceptions should override contract terms, but then I think this exception is a very important conception provided for in the legislation. So there is a genuine need for us to protect the users, and there is really a need to make sure that the effects of the exception will not be undermined. In fact, I have discussed this issue with Mr. Wong many times, and we still haven't been able to see eye to eye with each other. I've asked my assistant and the legal advisor to help me draw up a CSA. And so, Chairman, perhaps we can look at the proposed CSA at an appropriate time. Right. So let's see whether the administration has got any response, and then I'll ask if members have questions. Yes. Thank you. I thank Mr. KWOK for his comments and his amendment. As Mr. KWOK has pointed out, we've exchanged views many times on the matter. Yes, we understand that the spirit of free contract is not a sacred and inviolable principle. But then, of course, contract terms can be restricted only if there are very good justifications. And then second, is it that in this bill we are biased towards copyright owners? I do not agree. I think the legislation and the amendments all seek to strike the right balance between the need to protect the rights of copyright owners on the one hand, and the freedom of users to use these works without having to get the consent of the copyright owners first on the other hand. So we really are just seeking to strike the right balance. We first of all have to ascertain what products enjoy copyright. For example, music, literary works, and of course, there is a time limit for the copyright. And then at the same time, we have to provide for exceptions. So, the copyright belongs to a certain person, but then there are certain exceptions. We seek to draw the line very clearly, but then when the two sides enter into a contract on the economic rights, then the copyright may decide to grant a franchise or to grant a concession. And so there is the principle of freedom of contract here. Now, if something doesn't belong to the copyright owner, and when the copyright owner enters into a contract with another party, he doesn't have this right to also offer this right. And in the process, of course, there are certain negotiations as to what is covered by the contract and what is not. And so a clear contract will give legal certainty, and having the law overriding the contract may not be desirable. And also the amount in the contract should reflect the outcome of commercial negotiations. In fact, as we've stated in the paper, we have to be very careful about contract override. We don't think there should be contract override over or exceptions. But then when we decide that there should be contract override for certain exceptions, then what are the justifications? Freedom of speech, freedom of expression, or a lack of balance in the market. In fact, as we've stated in the paper, after this bill is passed, we will launch another round of review, and in the review we will definitely cover the issue of contract override. We understand that this is a concern highlighted by the users, and so we'll have to address that matter in the next round of review. Thank you. Now, I think the arguments that you've mentioned have already been made previously. So let's not repeat the points that have been made. Mr. Wong Yok Man. I thank Mr. Dennis KWOK for his concern and for the CSA that he has prepared. I think this issue of contract override is critical, at least to me, when I decide whether I support the bill. Concerning restricting contract override, the 22-page paper on proposed CSAs by the administration arrived only in the evening on Friday, and we have this meeting so early in the morning today. I wonder whether members have all got enough time to study the proposed CSAs. So why is it that we have to be in such a hurry? We had 3 meetings in May, 4 meetings in June, and 3 meetings in July. So we are all hurried. by the chairman and the administration. In fact, last week, and I had a meeting with my assistants. We were very puzzled and concerned. We received the CSAs only in the evening on Friday, and we have this meeting at 8:30 today. Is this really the right approach? I'm not being fastidious. I'm not trying to find faults. I'm not trying to make things difficult for the administration. But I think this is not the right way to scrutinize legislation. Oh, Chairman, it's meaningless to schedule meetings so frequently if the administration can't provide papers for us well in advance. We simply don't have enough time to study the papers. Now, this bill is different from the 2011 bill. This time we have the safe harbor provisions so that we know that you want to strike a balance among the interests of different parties. And then I think the most important section is 39A, the new fair dealing exception for parody, caricature, and pastiche. And then Chairman, Mr. Wong, let me finish. Now, Mr. Wong, let's now first of all deal with Mr. Dennis KWOK's concern first, because you are starting from scratch again. I'm giving the introduction. I'm giving the preamble. There's no need for you to give a preamble. We are on this paper. Now you are accusing me of scheduling too many meetings. In fact, I spent only 1 minute on the preamble. All right, let's activate the timer. No problem. All right, 5 minutes. 5 minutes for each member. 39A, Chairman. No, because we have to. Society has to decide whether it is willing to accept the exception under 39A. Because I have to go through the arguments. I can't just say 39A and then I say I can't accept it. I have to give you the background.
But you don't allow me to say it. If in 39A you can have contract override, how can we accept exception for 39A? In fact, we cannot even accept the entire bill. Therefore, if there is only exception under 39A, and if you also have contract override, how can I accept it? This is what I mean. And as to the paper provided by the administration telling us what happens in other jurisdictions. In UK, there is legislative subsidiary legislation restricting the contract override, and also there will be fair use exceptions. This uses subsidiary legislation as the restriction. This is not ideal. Why does the UK government still want to make such suggestions? I think we have to think through it. I don't know what the administration thinks. It doesn't carry the stance of the administration there. We believe in a commercial society like what we have now. The UK will think that without such restrictions, the fair use exception will come to nothing. That is why they have this provision. And then in paragraph 4, it says in the UK, introduction of such a categorical restrictive provision has been controversial. Public views received during the consultation exercise in 2011 were distinctly divergent. We don't find this strange because the controversy is almost as controversial as the exception for parody, satire, caricature, and pastiche. Therefore, the controversy on the restrictive provisions are really about the extension of controversies with regard to fair use exception. Now, unless 39A is just a front to get members to support the bill, or else you must introduce restrictive constructions. You must respond to this point. Actually, I have a long statement to make. You can start the clock ticking, and then I am willing to stand in the queue. please do not play tricks. If you want to play tricks, I will play tricks with you. I have many CSAs at hand. I have spent a lot of time on this bill. We believe the UK mode is okay. They make the legislation first and then they make a review later, and it is an undertaking given by the UK administration to the upper house that there will be a review after 5 years. If the creator or author is exposed to economic loss, then he can have redress. If you think 5 years is too long, you can shorten it to 3 years. That can be a compromise. And if you look at Australia, they also have their Law Reform Commission, which supports the principle of freedom to contract. But then with regard to exceptions for copyright owners and also copyright considerations, they are willing to allow some exceptions if there will be some restrictions on libraries and archival offices, then those will not be valid. And then if the contract override should be supported, then it should cover comment current affairs reporting, the provision of professional ideas and advice, and also parody and pastiche, etc. Also, if there is archival use, library use, school use, and also for facilitating the disabled, then there can be fair use exception. And then in Ireland, in Section 2, Bracket 10 of the Copyright Act 2000, it states that where an act which would otherwise infringe any of the rights conferred by this Act is permitted under this Act, it is irrelevant whether or not there exists any term or condition in an agreement which purports to prohibit or restrict that Act. The Copyright Review Committee recommended in 2013 that any contractual term which unfairly purports to restrict an exception permitted by Irish copyright law should be void. The administration has also covered other jurisdictions. So we should analyze it and try to understand it. Since the clock has already sounded, I will allow other members to speak. DS, you should note down what Mr. Wong has said because he has asked 1 or 2 questions. Mr. Raymond Chan. Thank you, Chairman. I tend to agree with Mr. Wong. Why do we have this pace at this meeting? What is the purpose of having this pace? Because I don't think we can have the bill passed. Now, on the 15th, we are going to have 2 sessions of the meeting, and many members actually are going to fly out of Hong Kong. So maybe we cannot have that meeting. Are you trying to do everything and complete everything before the summer recess so that we can start to queue up in October? Theoretically, we can still introduce CSAs into the Bills Committee, but I don't know whether there will be time to discuss. I hope you can give us reasonable time to discuss the CSAs as well. I'd like to ask members to express their views with regard to the pace of our meeting. Is it that you can definitely come on the 15th and the 22nd of July for meetings? Coming back to the proposed amendments by Mr. Dennis KWOK, I definitely support it, because if you do not limit contract override, then there will not be a lot of meaning to the exceptions. I can tell the administration frankly, one core issue of the entire amendment bill is about exceptions. Now we are at the final stage. If we do not properly deal with contract override, then we will have no choice, perhaps, to vote down the bill. And in fact, not just to vote down the bill, but to use other means to stop the passing of the bill. In fact, I am very fair. Some people outside say that the bill is Article 23 for copyrights. I have told them not to do it. But then, if you are playing tricks and you say, take it or leave it, and then you try to hurry us along, I think that will cause some negative reaction. And I can remind the administration that for the July 1st March, this bill is one of the themes. And in this committee, we should not be confrontational. We have been very rational in discussing how we can balance the rights of different parties. Coming back to contract override, of course we know if a contract can override all exclusions or exceptions, then our efforts spent on the bill will be wasted. The administration said you will need a lot of time for discussion, but then in the first instance, did you introduce this discussion into the consultation for amending the copyright law? And the other countries have spent over a few years on discussing this. Doesn't mean we will need the same time. Other people took a few hundred years to develop democracy. We don't have to go through the same process because we can learn from their experience. In the UK, they have decided to monitor the situation and has promised a review after a certain time. Can we go for a similar approach? Is it that from day one, since we have not introduced this for discussion and therefore it is too late to introduce it now at the final stage of the bill's enactment, are you saying that we need another few months or few years to discuss it? I think this is not fair. You are trying to hurry us along, saying that there is no more time and other people have used over a few years to do it. Sometimes you copy from other jurisdictions but only copy part of it. You say you have used the UK law as the blueprint, but then you do not follow everything that the UK does. So it seems you're a bad loser. You don't want to discuss anything that will benefit the netizens, and then you will say, too bad, we don't have time, just take it or leave it for the moment. Now, I don't want to give the public this impression. DS. Thank you, members, for your questions and your reminders. I think I can respond to a few points. First of all, we are not bad losers. It is not that we did not introduce this discussion into the consultation. Neither are we trying to hurry members along. This is not our intention at all. Now, why did we not consider contract override? Actually, the rationale is in the paper. Number one, some of the arguments have been covered, as I was reminded by the chairman. Actually, all along, there are these exceptions. They are in the bill. There are 10 to 20 of them. And then under our system, we do not have such restrictions. Do we see a situation where the exceptions do not apply so that there will be unreasonable restrictions on the user? I don't think we are seeing that phenomenon. If that is the case, then under our legal system, there are already appropriate arrangements to deal with this. Do we want to rush into such an amendment today? That's the first point. Secondly, yes, we can look at other countries for reference, as we were reminded by Mr. Wong Yok Man. Like in the UK, they did not start in 2011 but in 2006. And in Australia, in 2002, there was already a report on contract override. In the end, the UK has just introduced this amendment lately. And it is actually done in a piecemeal manner. It has been introduced for just a few provisions, not for dozens of provisions. Is it that we have to think about the prevalence of such restrictions? And then in Australia, the RRC has got this proposal, but then the government there has not made a policy decision. It was in 2001, 2002 that Australia started to look at the relationship between contract override and copyright law. However, they have not introduced any amendments yet. But have users been affected when they use copyright works? I don't think so. And then Canada, New Zealand, and EU, we have covered them in the paper. And when they looked at InfoSoc directive, the 20-odd directives, there was a discussion, but in the end, the EU did not adopt such an approach. So they have thought about it, but they have not done anything. It is not that we are just copying from these examples and that we are a bad loser. No. But we have considered the situation in other countries, and I am trying to use this as proof or justifications to say there may be some considerations behind this matter, and that is why we have covered these in the paper. And also, there is another very important point. Contracts only cover the two parties to the contract, and the contract is entered into by the two parties at a certain time under certain circumstances. We are talking about a private relationship, but then the exceptions will apply to everybody. So the exceptions will still be valid. Can I please have an answer on the legislative timetable? We'll take that up with you later. Mr. Wong Yok-man, I can respond to the DS. The administration cannot say the UK does not have express provisions to ban contract override, and you use this as an excuse. After we have this bill now, we don't know when we will have another chance to have a go at it. Mr. Dennis KWOK has raised a very important point. You mentioned the EU, but in terms of data bank and software, copyright exception is protected. There is no contract override possible. But the protection does not include other works. You have mentioned all these jurisdictions, and they are studying how to improve the situation. These are all common law regions or jurisdictions. We are now trying to amend the law. Why don't you also do something about this restriction? And also, I'd like to talk about freedom to contract. We mentioned these jurisdictions, they practice common law and they also respect the freedom to contract. But to different extents, they also put restrictions on contractual terms. And since we are embarking on this exercise, why don't we also do it? Do I have to wait 10 years, 20 years? The international mainstream intention is that yes, there is freedom to contract, but then the laws should also be able to restrict contractual terms. That is the spirit. What are you saying? You do not have a specific response. Like Mr. Dennis KWOK, he is proposing a CSA. But you are not responding. You have a totally different thinking from ours.
It is not that we have a conspiracy theory. It is not that we think the devil is in the details, and you are deliberately creating this problem in the legislation. Now, I think members' views are very clear. I understand that Mr. Wong Yok-man is trying very hard to persuade the administration to come round to his point of view. So the administration can respond again. We've received Mr. Dennis KWOK's CSA, and the CSA will be distributed to members. I believe Mr. Dennis KWOK will be moving this CSA, and then members can decide whether they will support the CSA. Yes, Deputy Secretary. Chairman, may I refer to para 24 of the paper? In fact, there are many exceptions, and we think that these exceptions can achieve the desired effects. And we do not think that the exceptions will be affected by private contracts. And then as to whether we should select a few items to work on, we have to look at the justifications very carefully. Is it because of freedom of expression? Is it because of a lack of balance in the market? And in fact, there are, apart from this one, there are also other controversial issues. For example, the TV boxes, and also the aggregate link sites, and so on and so forth. In fact, we have already said that we will carry out a review as early as possible. After the legislation has been passed, we'll try to make available the resources to look at set-top boxes and also link segregating sites, and also UGC, as mentioned by Mr. Wong Yok-man. Now we can see that in many countries, the situation is similar, and and I don't think they really have very major problems. And in the WIPO, there is really no mainstream view yet. Can you tell members the timetable of your review? 3 years, 5 years, or what? In fact, last time members asked when we would follow up on on TVB's concerns. Now we need to consult the users, the copyright owners, all stakeholders. The government has to analyze the situation, has to issue a consultation paper for public discussion. And also we understand that the LegCo has a 4-year term. So if this bill can be passed within this term, then we will have to try to make use of the time available in the next term of LegCo. We need to look at how we can strike a better balance between the rights of copyright owners and the rights of the users. Mr. Martin Liu, concerning contract override, I understand that there was a very lengthy discussion in Australia, and there was no decision made to restrict contract override. And then in the UK, I understand that they have an express provision, but they are trying it out, and then they'll see whether there are any problems. In fact, in the UK, they have introduced this restrictive this provision only recently. So why is it that we can't monitor the UK experience and then decide on our way forward? I don't think this is really a very very urgent matter requiring urgent action. So the Deputy Secretary has already promised that this matter be addressed in the next round of review. So let's look at the experience in the UK. It doesn't mean that we have to be the pioneer. Let's look at the UK experience. And also the UK situation may not be exactly the same as the Hong Kong situation. So let's look at what happens in the UK, and then we decide whether we should take things forward in Hong Kong along those lines. Mr. Chen Shih-chun. Thank you. Now, I understand that Mr. Martin Liu's perspective is in fact the administration's perspective. In other words, we'll can look at what others do, the effects. But then our view is that we do not want the rights of netizens to be undermined. Let's say A sells a script to B for the shooting of a film, and then there must not be any parody, caricature, for example. But then with this exception, then is it that B or what can B do? I think we are talking about those to be covered by the new fair dealing exception. Those who parody a certain section of that script, for example. Now, I believe the contract will not say that the rights of education institutions will be restricted, and that library use or use in the library will also be restricted. Say in the contract, if it is said that there cannot be parody, caricature, then of course the other contract to the party or the other party to the contract will have to be bound. And then for the netizens, if they are aware of the terms in this contract, and they may decide not to do any parody or caricature because they are worried about the possible legal consequences. And as a result, their creativity will be restricted. In other words, these people dare not do anything because they do not know the legal implications and consequences. Now, say the copyright owner of a cartoon and the social media website have already entered into a contract, and as a result, netizens may decide not to use the fair dealing exception that is provided for in the legislation, and that's our concern. Yes, Chairman, thank you. Say I have written a very good novel, and I am selling the copy. I'm allowing a person to use the copyright to shoot a film. And in the contract, it is stated very clearly there can't be any parody, caricature, or pastiche, for example. Then with Mr. Dennis KWOK's amendment, if it is passed, then the person who buys the copyright under the contract may still carry out parody, caricature, and pastiche, because that would mean that the term or this term of the contract will become unenforceable. That's the first point. And then second, the platform. Is it that because of the existence of such contract arrangements, netizens will be deterred from producing creative works? Now, the platform is or the contract is between the copyright owner and the other party. For those involved in secondary creation, they are not parties to the contract. They are not subject to the contract terms. They can enjoy the safeguards and the exceptions in the legislation. So they will not be held liable because of the existence of the contract. I'll say, say if I have a platform, I do not allow a parody, caricature. Yes, in that sense, you may say that the rights of netizens are restricted. But then I want to say that we really do not have justifications at the moment to speculate in any such direction. So the contract only binds the parties to the contract and not the netizens in general. I do not quite agree, Chairman. I will just finish this part, and I will talk about the effects on the economic interests of the copyright owners and other points. I want to say that the freedom to enter into a contract is not absolute. Sometimes the two sides to the contract have different bargaining power, and so can we still say that there is the freedom to enter into a contract? Look at contracts between employers and employees, contracts signed with telecom companies for mobile phone services. And in fact, very often the party with poor bargaining powers, in fact, has no say but to accept the contract terms. Copyright owners already have declarations for reservation of rights. So why is it that government libraries can just buy those books and allow people to borrow those books without having to compensate the copyright owners? Now, this is because the copyright legislation doesn't only seek to protect copyright. We have to promote freedom of information. We have to safeguard freedom of expression, freedom of speech. At the same time, we have to balance these rights against the rights to against the need to safeguard the rights of copyright owners. So these are not empty slogans. We have to put these into practice. So these public policies and legal or legislative intents have to be taken into account. But then I want to say that these restrictions will lead to an upsetting of this balance. There are consumers who have very little bargaining power. They can only choose whether to buy or not to buy. And if they want to buy, they have to comply with the terms laid down by the copyright owner. And if these terms are overriding, then the copyright owner may also restrict the rights of consumers and those involved in secondary production. So I'm talking about Part 2, Division 3, in other words, the use of copyright works and at the same time, I understand that the economic rights of copyright owners will be affected. I understand that the government wants to make sure that copyright owners will get reasonable remuneration or rewards for their copyright. But then I think you're contradicting yourself. Para 21 is about this use of copyright works.
It says individual users may enter into contractual agreements with copyright owners on terms mutually agreed, that is, to license the use of copyright works for specific purposes. It is possible that the owner may, at the same time of granting the license, secure an undertaking from the user not to engage in certain permitted acts, but only for a consideration that the user is willing to pay and the owner is willing to accept. Importantly, this private undertaking will not affect all other users who are not parties to the contract. The benefits of Part 2, Division 3 remain intact as intended. If the non-party to the contract is not part of this, and if the benefits of Part 2, Division 3 remain intact, then how can you take care of the rights of the copyright owners? Normally, there would be more people who are not party to the contract than those who are. And everybody will be able to act according to 39A to do secondary creation. But then those who are clients of the copyright owner will not be able to do this. If numerous people who are not parties to the contract can deprive the clients of the benefit of fair dealing, then how can you make sure that the copyright owner will be able to get the right kind of compensation? Also, you need exception from the court before you can apply the principle of fair dealing. And making use of 39A, when the court tries to make a decision, it will have to look at all the factors attending the case and also the ABCD in 39A, and I will not repeat those. As for those with a commercial nature, they will be excluded. So you can enjoy the exceptions under 39 capital A, and theoretically there should not be a big impact on the rights of copyright owners. If you use this as the justification to refuse to provide amendments in order to limit contract override, this is very unreasonable. And number 3, you do not have a clear division of rights. In para 23, you say, where a contract term is found to be contrary to public policy, it might be unenforceable. There is room for judicial intervention where important public interest is at stake. The doctrine may also be subject to statutory encroachment, for instance, consumer protection legislation such as the Unconscionable Contracts Ordinance discussed below. We have to point out that ever since enactment, there have been so few cases under the Unconscionable Contracts Ordinance. It goes to show that it's very difficult to comply with the standard of that ordinance. And also, fair use exceptions are statutory exceptions. If you allow contract override to limit those provisions, and if you want to ask the court to decide whether those are unconscionable before they are enforceable, then you are actually wasting time and creating trouble for yourselves. And the legal liability of the different parties is unclear, and there will be unnecessary judicial arguments. In fact, some of the judicial processes will be unnecessary. If you make provisions to limit contract override, then no matter what the content of the contract is, everybody will know their own legal liabilities. And lastly, the copyright law will attract copyright owners and creators to come to invest in Hong Kong. If the law will be clear to say that the fair use provision will be protected and will not be exploited by contract override, then that would protect the creators. This will not always happen, but then the administration has the responsibility to clearly delineate the rights and obligations of different parties. We have to look at things from all these angles. I hope you can respond to what I said just now. You say that there will be serious economic losses caused to the copyright owners, unclear legal liabilities, and also freedom to contract is not absolute. Okay, DS, I think a few points have been made. You can give me a written reply. I'd like to respond. I have followed the discussion. I think they still have a lot of misunderstanding. I can respond. First, freedom to contract is not absolute. I understand. I don't want to discuss this with you because this is an ideological discussion already. I think we are so divided. Well, okay, he wants to respond. Even if you have a big divide between you, I think you have misunderstood something. DS, can you now explain? Thank you, Chairman, and thank you, Mr. Wong, for your follow-up questions. We understand and also recognize that freedom to contract is not absolute. Under common law, freedom to contract is not absolute. Mr. Wong read out para 23 as Mr. Wong was saying. Under common law, we have certain restrictions like public policy, and some contractual terms may not be enforceable. If there is an important policy, public policy, of course there is not a lot of case law. However, we believe that this is already a very important safeguard under the common law. Also, statutory provisions. Mr. Dennis KWOK mentioned other law ordinances, and we need to provide statutory encroachment upon such freedoms. I definitely understand what Mr. Wang was saying, that the parties to the contract may have different bargaining positions. So, for the sake of public policy, we have made the Unconscionable Contracts Ordinance in order to protect consumers. This is because consumers have lower bargaining positions. Mr. Wang said there have not been too many cases, that is why the ordinance is not very useful. I don't agree. We have drafted the law and scrutinized the law, and now there are statutory provisions. They provide protection. So people in society will know what can be done, what cannot be done. We don't necessarily have to have cases in order to judge whether an ordinance is good or not. Now, why is it that books can continually be lent out from a library? This is because in making copyright law, we did not give particular rights to the copyright owners where after the book is sold, there will be limits on the lending of the book itself. When we draw the line to property right, we have already said that when the book has left the copyright owner, that physical object can be circulated without restriction. This is the first sale doctrine in the UK. Last, we were asked whether there is a conflict if parties to the contract can be limited vis-a-vis parody. However, third parties all over the world can engage in parody. Would that be more unfair to the copyright owner? I won't look at it like this. When we draw a line to property rights, we have already said that parody and its rights do not belong to the owner. From the point of public policy, we believe there is a bigger public policy consideration that parody should be afforded to everybody in the world. This is how we draw the balance. But then, if someone wants to enter into a contract with the writer, say if a novel will be turned into a screenplay, then I believe it works, that we should limit it. Why not? Mr. Martin Liao. With regard to freedom to contract, we all know that it is not absolute. Whether in the UK or Australia, they have recognized that point. And in fact, there are limitations to the freedom to contract. For example, contracts may be entered into in unfair circumstances. That is why we have laws to protect parties which do not have equal bargaining positions. Usually there will be special treatment vis-a-vis freedom to contract. In the UK, we have Unfair Contract Terms Act, and Hong Kong we have the same ordinance with the same name. And also under common law, because we want to deal with unequal bargaining positions, we have such protections as borne out by certain laws. Say, for example, a singer was not famous and he or she might enter into harsh contracts. And the courts would usually strike down such terms, saying that these are unconscionable contract terms. Therefore, when there are parties which do not have equal bargaining positions and they enter into a contract, there will be protection under the common law and also statute law, especially under common law. The same goes to goes for the employment ordinance. This is also about protection for people with unequal bargaining positions. On freedom to contract, unless we can see evidence that there is an unequal bargaining position, the court will not want to interfere. And in fact, this is not what we are seeing. And I don't think we should first interfere before we see such cases. I have reservations. Mr. Raymond Chan. Thank you, Chairman. I understand we cannot have an unending debate with the administration. But I'd just like to state my position clearly, and I want the administration to explain their viewpoints. The administration and you, Chairman, say that the contract will only limit the two parties and not a third party. But when we are talking about parodies, that is not the reality. Just now the DS said if a copyright owner wants to sell his works and turn it into a screenplay, and with Mr. Dennis KWOK's proposed CSA, we cannot write down something like faithful adoption of the original works, that tragedy cannot become a comedy. I know that is your reply, but have you got such cases that you can let me know about, like in the UK? Are you talking about the real world? Is it really that with Mr. KWOK's proposed CSA that will certainly happen? And if that's the case, can we not improve on the writing of that CSA? And also you say it only limits the two parties to the contract. Let me give you an example. A copyright owner signs a contract with a social media platform that my works should not be parodied. And for me, a third party, to do it, then the copyright owner cannot take me to task for legal liability. But then in reality, if I upload it to the platform, the owner of which has entered into a contract with the copyright owner, of course I will be deleted. But that deletion, will there be a legal problem? You have signed a contract with A, so you delete what I upload. But then in the law, I am accepted, I have exemption for doing parodies. Should a citizen then take platform B to the court to say that platform B does not have the right to delete certain uploaded material? And also in reality, the platform may be a mainstream platform and a lot of netizens use that platform. And also for copyright owners who are multi-international film companies who are very rich, and they also sign similar contracts with other social media platforms, then I do not know where I can upload my creation. And you can say, of course, you can open your own platform. And you say if you do not sign a contract with the copyright owner, the contract override will not be able to limit your freedom. Thank you. I can make 3 points, actual cases or examples. I think I was trying to explain on the basis of legal principles. Now, of course, we can write it better, like in Ireland. They talk about whether a contract is individually negotiated. That is one possible way to do it, but we have not thought it through. You ask for actual cases to prove I'm right. But then on the other hand, we cannot see cases saying that exceptions have become void because of contract override. And also the right to delete certain things from a platform on the internet. Actually, the operation of the platform is a private decision. If I operate a platform, even if I have no contract with copyright owners, if I encourage original creation, then the platform owner can make his own policies as to what should be uploaded or not. If you ask the administration to interfere and force platform owners to do certain things, I don't think that is something we want to do now. Undoubtedly, the operation of many platforms can upload anything for free. And how the platform operator can continue to operate the platform on that basis is up to him, and I don't think it's right for the administration to interfere and force platform owners to do certain things.
And then is it that without this provision, then all the other platforms will do the same? As a result, the room for creation will be restricted. But even if there is a provision, it doesn't mean that they will not be doing that. It is just that the term may not be enforced, but then for the platform may decide that enforcing the term will be to its benefit. And only if there is a breach of contract can the owner go after the platform operator. So I just want to say that this term or this provision can't help resolve the problem. The law can't solve all the problems. A lot depends on the actual circumstances. In fact, in overseas countries, there isn't such an express provision, and we haven't seen any problem concerning the operation. Right. So I think we've already dealt with Mr. Dennis KWOK's paper. We note the difference in views. So now, members, let's move on to paper 1233. So who can take us through this paper, Ms. Chong? Let me say a few words first, Chairman. Sorry, Chairman, the paper reached members rather late. In fact, we have 3 meetings in July, and so if members think they haven't studied the CSA's in detail. We can go through the CSAs later. But then I think these CSAs are relatively simple. We can have discussion, but I don't think there will be a debate on the CSAs because the CSAs have been proposed in response to members' suggestions. Yes, Ms. Chong, please. Chairman. These CSAs have been proposed in response to suggestions made by Mr. Wong Yok Man and other members on the drafting of the bill. So some of the amendments have to do with the use of the conjunction and or so members can look at the CSAs. We have accepted many of members' suggestions. But then we are unable to make certain amendments because we need to strive for accuracy in the legislation. And we have adopted many of the suggestions put forward by the legal advisor and Mr. Wong Yok Man. And then concerning whether certain conditions have to be met and so on and so forth, we want to make the provisions clear and readable. And that's why in para 8 we have listed certain provisions with this style of drafting. And the purpose is to have the drafting and the wording more in line with the usual Chinese style of drafting. So there will be these amendments. On the safe harbor provisions, Mr. Wong Yok Man has proposed some amendments. Some of them have already been accepted. For example, in the English version, the word widely is replaced by the word generally. And in the Chinese version, we have deleted haven't received before and have replaced this with have not received and are not in the process of receiving. Coming to the adjective, จิตตะ, members did ask whether that was a suitable translation. We have made reference to IT menus, and we think this adjective, จิตตะ, is appropriate. Finally, or otherwise is prejudicial. Mr. Chair asked whether it should be or is otherwise prejudicial instead. We think the two versions are very similar. And in deciding whether it's really prejudicial, we have to look at whether there is any prejudice to the honor or reputation of the author or the director. And we think that the original wording can clearly reflect this meaning. For the amendments, members can refer to Annex A. Unless members have any questions, that's all with regard to my introduction. All right, any questions? No questions? The legal advisor has prepared a marked up copy for us covering all the proposed CSAs. Mr. Dennis KWOK has already given us his amendment. Mr. Chen Chi-chun asked a question about our legislative timetable. I said that we're going to have another meeting on that CSA. Now, because we'll have to wait till Mr. Dennis KWOK formally submits the CSA, and then members can decide whether the CSA should be moved by Mr. KWOK himself or by the Bills Committee. But then Mr. KWOK is not present at the moment. So we wish to deal with all the CSAs. And then I will give a report to the House Committee. If I can't do so within this term, then I will do so on the 9th of October, after the beginning of the new session. And then resumption of second reading can take place on the 28th of October. The deadline for giving notice to move CSAs will be the 19th of October. So there's no need for you to write down these dates. The clerk will issue the legislative timetable to members later. So the only outstanding issue is Mr. Dennis KWOK's submission of the CSA, or of his CSA. Yes, a legal advisor. Chairman, I want to say that there was one point raised by Ms. Claudia Mo on an amendment, and I think this has been omitted, and I've already alerted the administration to that. Deputy Secretary, Mr. Lam? Yes, Chairman. I'll give members a report. Ms. Mo said that there was a discrepancy between the Chinese version and a and the Chinese version and English version of Section 202. But then we studied the two versions, and we felt that there was no discrepancy between the two versions. It's true that in the Chinese version there are more characters, but then the meaning of the two versions is the same. So you're not going to propose any amendment? No. Mr. Chen Chi-chun. Chairman, because I also intend to propose some CSAs, but I won't be able to finish the drafting within the next few days. So is it that we're going to deal with Mr. Dennis KWOK's amendment at one of the meetings in July, and what if other members also have CSAs to propose? Because the deadline for giving notice to move CSAs is the 19th of October, so you can, before that date, put in CSAs, and once we've received the CSAs, we'll convene a meeting, and at the meeting you can introduce your CSAs, members may ask questions, and they can decide whether they support your CSAs. But of course, there will not be debates anymore. We will just look at the CSAs. And so it depends on whether members have other CSAs. So if there are no other CSAs, then we will only have one more meeting. Yes, correct. Our next meeting will be held at 2:30 on the 6th of July. Right, members? Any more questions? So at the next meeting, we will deal with Mr. Dennis KWOK's amendments and other amendments. And if we can deal with all those amendments in July, we not have further meetings in October. Deputy Secretary? Perhaps we can have one more meeting in July to discuss the CSAs, because we've scheduled some meetings for July. Yeah, I understand, but then members can always put in CSAs before the deadline in October. If no CSAs are received, we'll not hold further meetings. Right, if members have no other points to make, then the meeting is adjourned. Thank you.